friends, I want to talk with you a little bit about civil rights and sex discrimination. So, as you'll see the slide pop up, let's chat a little bit about the role of suffrage and how that shifts a discussion on sex discrimination. And then we're going to talk about some cases that are pretty prevalent and speak to how the court has ruled about civil rights and what equal protection of the law means when we're talking about women. So my first bullet point up here is about suffrage and the 19th Amendment. I'd like to remind you all that we're looking at the 100th anniversary of women getting the right to vote via the 19th Amendment. So the 19th Amendment was passed in 1919 and put into effect in 1920. And what this does is it drops the gender or sex requirement that previously indicated that men had the right to vote. Right now, women have the right to vote too. And this kind of kicks off this whole new era in how women start to seek equality in American society. Right after the 19th Amendment was added to the U.S. Constitution, there's a movement to add another amendment to the U.S. Constitution. And I don't have this bullet point on here, so I don't want you to think I'm just kind of going off on a tangent. But it's quite relative, in fact, as we're going to chat a little bit about. So starting in the 1920s, there's a movement to add what's called the ERA, which is the Equal Rights Amendment. And Alice Paul, who was one of the big movers and shakers in getting the 19th Amendment added to the U.S. Constitution, is the person behind the Equal Rights Amendment. So we're going to do a little bit of research on the Equal Rights Amendment, and I'm really going to encourage you to push pause on me now and to look online, because there's been a lot of movement towards the Equal Rights Amendment, as Virginia was the last state to ratify the amendment, actually, which would mean that it should be added to the U.S. Constitution if it weren't for a time expiration. So I'm going to encourage you to push pause and to do some quick research on the Equal Rights Amendment and where it stands right now, and then rejoin me back into the lecture. Okay, so hopefully you did a little bit of research. And any questions that might be emerging about the ERA, I'm happy to talk with you about on Monday. So hold them, write them down somewhere, get a sticky note, make sure you don't forget them. So one of the things that we start to see in the 1920s through the 1960s is this desire to fight back against an era of protectionism. What do I mean by that? Well, many laws prior to the 1920s actually sought to protect women as a special class and to not treat them as an equal class or an equal grouping to that of men. And again, we're talking about how the law viewed women, okay? So we see this case that actually emerged before the 1920s called Muller versus Oregon. And in Muller versus Oregon, the Supreme Court rules that it's perfectly legal for the state of Oregon to limit women's working hours. This is a case that is related to the amount of hours that a woman could work. The state of Oregon had put limitations on what a work day looked like for women, but allowed men to work longer hours. Now, you might be saying to yourself, wait a minute, what's the problem with that? It's men that are getting shafted over here because they have to work longer work days than women do. But I think you have to ask yourself, perhaps, what if women wanted to work longer work days? Or what if they needed to work more hours in order to support their families? Ultimately, the state of Oregon was preventing this from happening and was not treating women equally under the law. So Muller sues, and in Muller versus Oregon, the court ultimately rules that it is okay for women to have limitations on their workday because that they have this additional or special relationship that occurs between them and their children, and that it is in the best interest of women and their children that women be home to take care of their children. Now, it's perfectly appropriate if you agree or disagree with the case one way or another, but do recognize what that case is ultimately saying is that women and men are not equal under the law. We'll come back to that. So oftentimes what we see is this movement between the 1920s and the 1960s to kind of push on this era of protectionism and to kind of break down some of these rules. And we were seeing those traditional roles of men and women, much of what we've talked about in U.S. history about women's spheres and men's spheres. We were seeing that mirrored in the law. And so there's this new movement to make some adjustments to that And one of the biggest things that kind of happens during this time period that pushes on it a bit is World War II. Because with World War II, women leave their homes and they go to the workplace. And I don't mean like working class women, right, who were already working, who'd been working for generations, but really like middle class women started working in the workplace, right, and heading out into the factories. In fact, not terribly far from here, right, Kaiser Aluminum employed a ton of women in this region. So now that women are out and about in the workplace, especially middle class women, they start looking at the law in a very different way. And quite frankly, the law starts looking at them differently too. So from the 1960s to the 1970s, we see this big push in a desire to really break down barriers and what equal protection of the law means. And there's a couple factors. So one, it's a reaction to the 1950s. And just as I indicated that World War II kicks off this time period where women are out of the home working, the 1950s, they're returning back to the home. Now, naturally, some women didn't like it, some women did. So it's not fair to stereotype one way or another. But ultimately, for those women that were dissatisfied from returning to the home and not feeling positive about what their role looked like or happy about their own, sustenance, there is this desire to try to figure out how do you change society so that women who wanted to work could feel comfortable working and not feel challenged, or not challenged isn't the right word, but not feel judged by society for choosing to work. The other thing we have to think about that really heavily impacts the seeking of civil rights and sex discrimination is the role of other minority groups being able to get access to more civil rights, right? And we see that through the conversations we've looked at over the past 2 days, particularly with African Americans in education and in other settings as you're looking at. So in the 1960s and 1970s, we see an increase in women's groups emerge, the National Organization of Women and the National Women's Political Caucus. There's a book that highlights the experiences of women in this time period called The Feminine Mystique, and those all sort of push heavily on women and men, as we're going to talk about, seeking equality under the law. So what emerges starting in the 1960s, 1970s, and from here on out is a movement to use the law as a way to ground civil rights for genders and sex. So you'll see here I've listed the goal. The goal is to use strict scrutiny as the applied measure to evaluate sex discrimination. Now, I don't want to get into the weeds of strict scrutiny and intermediate scrutiny or any of that because it might be a little over our heads at this point and maybe not necessary to the conversation. But essentially, understanding strict scrutiny is the same level of examination that the Supreme Court uses when they're dealing with race discrimination, right? So in very, very, very few cases is the Supreme Court ever going to hold up race discrimination, right? They see it, if there's a discrimination by race, they see it as an automatic violation of the Equal Protection Clause. So there are leaders in the legal community who want sex discrimination to be viewed the same way, right? To use that exact same measure that's used with race as a way of evaluating sex discrimination. And we see this kind of kick off in a few cases that I want to highlight for you. And the first is called Reed versus Reed. This case is in your case brief book, and I do want you to take a look at it. It really is one of the first cases that actually address sex discrimination. And so I'm going to encourage you to push pause and to find that case in your brief book and to do a quick annotation. The next case I want to talk a little bit about is Craig v. Boren. And I'm going to post a short 4-minute video on Craig v. Boren that I think is going to break down for you. This is a case that isn't your traditional sex discrimination. Oftentimes people think about sex discrimination, they think about women being discriminated, but sex discrimination does not have to mean that. So Craig v. Boren is a case in which men were being discriminated versus women. So I want you to take a look at that case as well. So both of those cases kind of highlight that there's some issues that are emerging in the 1970s about sex discrimination. Both cases, what's interesting, are both cases are argued by then attorney Ruth Bader Ginsburg, who eventually is now the notorious RBG and sits on the Supreme Court. But this is how she gets her start. Sex discrimination is something that she works hard and has worked hard to fight against, regardless of whether we're talking about women being discriminated or men being discriminated. Eventually, what we see is this shift to examine the role of civil rights in the workplace. So, the Civil Rights Act of 1964 indicates that all gender discrimination has to be banned in the workplace. And really, what does that mean? Well, it means that a business or company cannot violate or cannot prefer men over women or treat men and women differently under the law. And the Equal Opportunity Employment Commission in 1972 also established that if you're being discriminated because of your sex, that you can sue your employer. So there are some components here that allow for opportunity for people who have been wronged to seek compensation or at least damages in one way or another, or to prevent that wrong from continuing. In 1978, the Pregnancy Discrimination Act was passed by Congress, right? This isn't the court, but this is by Congress. And it makes it illegal for employers to exclude pregnancy and childbirth from their sick leave and health benefits plan. So prior to 1978, businesses who were offering health care to their workers decided that they would not cover pregnancy or childbirth. And so as a result, it decreased the likelihood that women were going to join that, take on that job, because if pregnancy and childbirth isn't covered on that insurance plan, then they may not want to actually work there because, you guys, it costs a lot of money to have a baby, just so you know. It's a lot. So as a result, a woman might say, hey, I don't want to work here. I can't afford to work here. And ultimately, with that, some workplaces would eventually be saving money because they wouldn't have to shell out dollars in insurance fees and fines, et cetera, because somebody was pregnant on the workplace. Also, when you're pregnant and you have a baby, there is some time off of work as a result. And some workplaces don't want their workers taking time off. So by not covering pregnancy, you're not as likely to have employees who are pregnant or who will eventually get pregnant. And so instead, they just quit their job. We do see some examples of civil rights and sex discrimination in education as well. Many of you have probably heard about Title IX. Title IX is in the Education Act of 1972, and it forbids gender discrimination in federally subsidized education programs. We oftentimes think about Title IX as related to sports, but it's more than sports. It's also academics. It is what requires under the law that women also be able to access the same facilities, the same resources, et cetera, as males or men within a system. So, for example, let's say that we have a lit baseball field and the boys' baseball team gets access to practice under the lights, but the girls have to quit practice when it gets dark because they can't have lights on their field because the school is choosing to not put lights on the softball field. So as a result, that's a Title IX issue. Likewise, if there are more girls' sports than there are boys' sports, you could potentially have a Title IX issue, right? The genders have to be treated equally under the law, and you have to provide the same sort of access points, regardless of sex. There's also the final situation here that I want to draw your attention to is the VMI case. And you have this case actually in your case brief book, but it's posted under U.S. versus Virginia. So please take a look at U.S. versus Virginia. This is a very famous case. I believe it was in the 90s. So, and it's forever kind of changed the way the Virginia Military Institute brings in new students. So I'm going to stop there. I'm going to link some videos as well, some brief videos, I should say, on some of the cases that I covered today and a few that are relative to all of this. As always, if you have any questions, please don't hesitate to let me know. We have a big day coming up on Monday. Monday is the very first primary. It's actually a caucus. for the presidential election of 2020. So I'm really excited because one, I'll be back on Monday and I've really missed you guys. And two, we have a lot to talk about with what's coming up with the primaries. And I'm happy to address any questions that might be emerging for you regarding impeachment at that time too. We're going to look at some articles to kind of get caught up and see where it is exactly that the process is. So I look forward to seeing you guys on Monday. I've missed you so much, and have a great weekend.